be standing here without these amazing supporters who have supported me and my team financially and, more importantly, emotionally.
We love Karen!
Cheers coming from the crowd in Dedham, Massachusetts, after Karen Reed was found not guilty of second-degree murder, manslaughter while OUI, and leaving the scene of an accident.
Do all of you agree? Yes. Thank you.
A 12-person jury did convict the Bristol County woman of drunk driving after a 2-month trial. The jury selection process started in April with a buffer zone in place for protesters. The court order changed as the trial continued.
We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice.
Close to 600 potential jurors came to the courthouse over 3 weeks. In total, 18 people were seated. Opening statements for the retrial kicked off in late April. A new face, Special Prosecutor Hank Brennan, led the case for the Commonwealth.
Good morning.
Reed was accused of backing into her Boston police officer boyfriend, John O'Keefe, with her SUV in January 2022, leaving him to die. She said she had dropped him off at a house party after a night of drinking.
Tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull.
Okay, no comments right now, guys.
Alan Jackson opened for the defense.
There was no collision. John O'Keefe did not die from being hit by a vehicle.
He's bruised up.
On the first full day of testimony, O'Keefe's mother, Peggy, tearfully took the stand. She recalled what Reed said to her the morning her son died.
Peg, is he dead? Is he dead, Peg? Peg, is he dead? And she said, we went to a party. I left him there. I said, you just left him there?
Jennifer McCabe, a high-profile witness, returned for the retrial. She described Reed's frantic behavior as the victim's body was found outside 34 Fairview Road in Canton.
I hit him is just as fresh today as it was 3 years ago.
McCabe had been at the house party hours earlier. Her sister owned the home. An early morning phone call and the timing of a Haas Long to Die in Cold search were under scrutiny.
Karen said it. It's that simple.
So you're the only person saying that, though?
Yes, and I stand by that 110%.
As the case progressed, prosecutors used a new tactic to lay out their case. Video clips of Reed were played for the jury.
I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out, and David said, yeah, then you have some element of culpability.
Angry voicemails Reed left on O'Keefe's phone also echoed in the courtroom. Reed demanding to know where he was during the early morning hours of January 29th.
At 1 in the morning, I'm with your niece and nephew, you pervert.
Inappropriate texts from former state trooper Michael Proctor were also read. Proctor, the lead investigator in the case, was fired for the messages. He didn't testify this time around, but Sergeant Yuri Buchanan did again.
No nudes so far.
Buchanan was Proctor's supervisor and had to forfeit 5 vacation days for failure to properly supervise.
Glanced at it, took part of the information that came through and acknowledged it with a thumbs up emoji, indicating that I read it.
Meanwhile, Brian Higgins, an ATF agent, had been flirting with Reed and was on video at the Canton police station after the house party. He didn't take the stand either, but Buchanan read the texts between the two.
You're hot. We did kiss earlier. No? I think you initiated that. No?
Another state trooper testified about broken taillight pieces found at the crime scene.
I believe in total we located maybe 6 or 7 pieces of taillight.
The state called its medical examiner about a week before their case wrapped up.
Were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
Then a new data expert, Shannon Burgess, caused controversy over his education.
You've been pursuing a Bachelor of Science degree for 17 years, correct?
That is correct.
And you have not obtained it as you sit here today?
That is correct.
And yet there are the various documents that we've seen that state that you have obtained a Bachelor of Science, correct?
Again, with errors or misinterpretation.
Burgess looked at data from Reed's SUV and testified about the time a backup event occurred.
Time of that event with the clock variance adjusted is 12:32:04 to between 12:32:04 and 12:32:12.
O'Keefe's cell phone was last locked in that window. A defense expert would dispute the findings.
Based on the initial reports,
Yes.
the phone interaction always occurs after the end of the vehicle event.
On day 20, there was drama with the jury.
An issue has come to my attention that is going to make it necessary that I talk to each one of you individually over at sidebar.
Dr. Judson Welcher, an accident reconstructionist, was the Commonwealth's last witness.
Do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Here's what Reed had to say about the state's 23-day case against her.
Unjust.
Reed's attorneys argued a Bowden defense in their case. They claim the police didn't do their jobs properly and didn't investigate anyone other than Reed. One of the most contentious days of the trial was when Officer Kelly Dever was called by the defense.
You threatened to charge me with perjury during our phone call prior to the first trial if I didn't lie on the stand right now.
She was working the day O'Keefe died. Reed's car with a damaged taillight was towed to the Canton Police Department.
That you saw Brian Higgins and Chief Berkowitz go into the Sallyport together and alone with the SUV for a wildly long time.
That was my recollection at the time.
But Dever says she later saw a timeline.
That the vehicle on that day did not arrive in the Sallyport until about an hour and a half after I left, meaning it is not possible that I saw that.
Dr. Daniel Wolf of the crash reconstruction firm ARCA testified about tests that were performed.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
On cross-examination, things were heated. ARCA had been originally hired by the feds, but then worked for the defense.
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Another dramatic moment in the courtroom when the defense asked for a mistrial with prejudice after a line of questioning about the victim's sweatshirt.
The Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminalist as part of their examination.
Here was Brennan's response to the
Yes.
scrutiny.
It appears that I made a mistake.
The motion was denied and clarification was given to the jury. Dr. Elizabeth LaPosada, Rhode Island's former chief medical examiner, was a new defense witness.
The pattern injury that you see on Mr. O'Keefe's right arm is consistent with an animal bite or claw marks.
Yes, it is.
She disagreed with the Commonwealth's accusations against Reed.
Well, it didn't hit him, so it doesn't matter.
This is what both sides had to say before the jury began deliberations.
She made a decision about herself. In her Lexus, she drove away. She was drunk, she hit him, and she left him to die.
There was no collision.
After about 4 days of deliberations and 2 sets of questions, the jury came back with a verdict.
In the second degree, what say you? Is the defendant at the bar guilty or not guilty? Not guilty. So say you, Mr. Foreman? So say you? No. Do you agree? Yes. Do all of you agree? Yes. Thank you. 002. What say you? Is the defendant at the bar not guilty or guilty? Not guilty.
Emotions running high in the courtroom as cheers were heard through the walls. The O'Keefe family in shock, the Reed family feeling relieved. We caught up with Karen's father, William, and brother Nathan just hours later.
Relieved, first and foremost. Proud, Karen, proud of this legal team, proud of my parents. Dad?
Still numb. You know, you after living 3.5 years of this nightmare, this terror, this fright, up against this power of the state and its unlimited resources to come after you. It's a nightmare. It's been hell, as I've said on many, many occasions. And right now, to have it over, it seems surreal.
Reed was sentenced to a year probation. A civil case against her was filed by the O'Keefe family last year. The wrongful death suit is making its way through the court system, and Reed could be deposed. Katie Benoit, NBC 10 News.